My lord, I could not prepare the case, my lord. The matter may be at the
Why you could not prepare?
because of fever, my lord. Last 3 days, my lord.
Because of fever.
Fever, my lord.
Now you're okay.
Now okay, my lord.
Okay, day after tomorrow.
Day after.
19 matter. Item number
Day
6,
after
huh?
tomorrow or Friday, my lord.
Huh? No, day after tomorrow, not Friday. You are, what is your name?
AHMR Choudhury.
On the request of, Sri HMR Chaudhary, learned counsel for the petitioner, has prayed for some accommodations on personal reasons as he was unwell. Full stop para. Considering the same and also the fact that this matter is pending since the year 2019, a slight accommodation is granted, a short accommodation is granted, directing listing of this matter on Wednesday date.
My lord, another prayer for listing of a new matter, my lord, on Friday, my lord.
My pleasure. It's on item number 34,
Yes.
admission matter. My senior RC corporate, he is preoccupied with an urgent meeting at NLU. The matter may kindly be listed after 2 weeks.
New matter, 34 is a new matter. Okay, when do you want?
After 2 weeks, no?
2 weeks. On a request. Yes, madam. On a request made on behalf of Dr. R.C. Borpatra Gauhati, matter is adjourned to be listed on today's 10th. On 24th? 24, 8.
Hello.
Lordship, I'd like to mention item 11 and 13 for adjournment, Your Lordship.
11 and 13. Why are you seeking adjournment?
Conducting counsel went to the hospital to treat his son, Your Lordship.
Who is not well?
Mr. M.S. Majumdar, the conducting counsel. Mr. M.S. Majumdar.
He is not well. Okay. 11 and
13.
13. On the request of on the request made on behalf of Sri A.M.S. Majumdar, matter is adjourned to be listed on Friday.
Friday.
Belek order, huh? 11 or 13, Friday.
Oblige, Your Lordship.
We'll do one thing, we'll have the fresh matters first. Item numbers 12 to 19. Thereafter, we'll have the old matters because old matters will go for disposal. Aquí voy a entrar. 12 onwards.
19.
Yeah, of course.
Mr. Ali,
Next is the law. In opinion, my lord, please 55.
25, 124 is the opinion.
Lord,
Why have you come late?
They are, my lord, very rusty women, my lord, and
It seems you are not concerned with the judgment. More than 2 years have passed, nothing has happened, so you do not seem to be aggrieved by the judgment. Heard Sri heard Sri R. Ali, learned counsel for the petitioner who has put to challenge an opinion dated 25/1/2024 passed by the learned Foreigners Tribunal First Nagaon in FT case number so and so, whereby the petitioner has been declared a foreigner post 1971. Full stop. What are your main grounds, Mr. Ali?
my lord, she has produced all documents, 65 onwards, my lord, and her name was
It is
also
contended that
in
the
land record, my
relevant
lord.
factors have not been taken into consideration while rendering the impugned opinion. Para, let notice be issued, returnable on 14th of September 2026. Union of India. Union of India. Who normally is there? Madam?
Keep changing every day, Lordship.
Because they do not have anything to do. They think they do not have anything to do. One day will record that they do not have, they are not concerned with the matter. Then they'll have something very much to do. Yes, call some CGC. What is this kind of thing? They're not concerned with deportation matters. Gap press, reassurance of CGC for one, Miss
2, 4,
A. Verma, London Standing Council Home Department for 2,
4 and 6.
4 and 6. ECI, MCNA on behalf of Miss Eskotoki, Standing Council ECI for 3. P. Sharma for 5. 5, that's all. Extra copies. Then call for the record of the tribunals into a registry to make the requisition. Okay. Yes, next.
She may be not deported, my date of the loss.
Shri Ali, the learned counsel for the petitioner, prays for an interim order, which however is strenuously opposed by the learned counsel for the respondents, para, considering the facts and circumstances and by balancing the equities, it is provided that till the returnable date, no action for deportation of the petitioner be taken.
All right.
May I please the lordship? Lordship,
Item number? Yes, madam.
lordship, kindly pass over the matter for time being.
Pass over.
Yes, lordship.
Okay, for the time being, let him come. Okay.
All right.
Impugned final order, lordship will find at page 87. Order dated 11/6/2026.
'87.
87, lordship.
What are your grounds?
Grounds, lordship, my father has deposed, filed his evidence on affidavit and stated that she is my daughter.
But will that have, how much significance will that have? Will that be a loan?
And the
Document in absence of documentary evidence and in view of the settled position of law.
the voter list of 1965 is there, lordship, of the
What is
father.
your age?
Lordship, present age.
Not at present, when were you born? What is your age, whatever?
68 born, 58 years lordship.
68 born.
Yes, 1967.
When is your first voters list? When did you vote first?
89, lordship.
Huh? 89.
89 at page 36.
Your father's name is there in that voters list? Not there.
Usman Ali.
আছে কিন্তু মই ফাদাৰৰ লগত থাকিলে বিয়াৰ পিছত
Because
মেৰিজ
after marriage, lordship.
That is the difficulty. So how do you, what is your documentary evidence that you were in India before the cutoff date, or there is a link of you with your parents? That is what we seek.
Yes. The Gauhati has deposed. Gauhati, lordship, will
Of which
find-
village?
of both the village, lordship, of Borbala as well as
Okay.
Bardanga. At page 81.
Heard 3 hours, heard learned counsel for the petitioner who has put to challenge an opinion dated 11/6/2026 passed by the learned foreigners tribunal number 8 Borpeta in FT case number so-and-so, whereby the petitioner has been declared a foreigner post 1971, full stop. It is submitted that the deposition of the father as well as other evidence, including that of the Gauhati, have not been taken into proper consideration. Full stop. Para. Let notice be issued. Returnable on same date, huh? Kiman disillo? 14/9. Who is there? Yes, madam. Devi. I go to LDB. LDB CGC 1. A Verma 2.
4 and 6 lordship.
2, 4, and 6. ECI, M. Sinha, on behalf of M. Sinha, and Eke Thakilo. Then District Commissioner Borpeta, P. Sharma. Extra copies. Call for the records. Thakile again, requisition koribo. Records of the tribunal, huh? Koribo. That he prays for an interim order. Submit that is yet to be arrested and prays for an interim number. Refuse hearing. Resisted. That's what he can do. Huh? Okay, you appear.
Yes.
When? Today is 10th. On or before 24th. 24th. On or before 21st.
Yes.
21st. 21st. Okay. And 20,000
Obliged.
bond. SP border, which one? Borpeta.
May I please, your lordship?
Item number, madam?
16,
16.
lordship.
Yes.
Lordship, the impin order is at page number 65, your lordship. The contested case, your lordship. Here, the petitioner been declared as foreigner because as per the recorded lordship order, your lordship, it reflects that due to not submitting of the linkage, your lordship, it is projected further, your lordship. At exhibit 13, we have submitted, your lordship, the school certificate, your lordship.
What are your grounds?
Yes, your lordship. Exhibit 13 is school certificate, your lordship. Two certificate, your lordship, one of Panchayat and one of Gauhati.
Why are you late in approaching the court?
Because, your lordship, I have mentioned it at paragraph number 25, your lordship.
What is it?
Because, your lordship, that time, your lordship, I rustic villager, your lordship. I don't know the circumstances of this lordship order, your lordship. So as per the, everyone told me that is really not adverse circumstances, your lordship. And when the state has initiated the pushback policy, then I got realized, your lordship, that I have to approach your lordship. So
What is your synopsis, the first line? Please read the first line. What is the meaning of this, madam? We have not understood. Please
that's
explain it to us.
wrongly typed, your lordship. My apologies.
So what is this?
Wrongly typed, your lordship.
We try to understand your case. We do not understand.
Lordship.
You have to take the first line itself. What you write, you do not know.
My apology, your lordship.
To take care in this.
Lordship, lordship. I'll take care, lordship.
Heard. Miss G. Bora, learned counsel for the petitioner. I Patham to this first case to listener. Ordered it is on 33/2023. Ekdam exactly.
State order.
Union of India, one LDV, PCC, TCI M. Sinha on behalf of S. Kotaki 2, then Madam Verma for A. Verma for 3, 5, 7. What about 8? 8. Then 6 P. Sharma. Top kata hoise na? 419. 4 Chief Election Commission, Chief Election Officer, Assam. Oh, you are for 4? 4? No, Madam, 4 and 5. M. Sinha 4 and 5.
4 and 5 would be.
Only for ECI. Only for ECI.
4 and 5. And 4 and 5 are Dubey. Is he there in the court? Mr. Dubey? Are Dubey 4 and 5, huh? So, call for the record, deke hobo. So and so, learned counsel, prays for an interim order which is strenuously resisted, better. Considering the person to understand, should not be reported to. Okay.
Short delay may be taken.
The the Ms. Verma, the learned standing counsel, Home Department has raised an objection questioning the maintainability on the ground of delay. First of the aforesaid aspect is kept open. Yes, madam.
May it please your lordship. Lordship, impugn order is at.
You have
page
not
30.
changed your handwriting. You said you undertook.
I told.
So what is this?
He has given.
We remember what we
Yes.
say, what we delivered in this court.
I have
You
done.
have not
when
done
you said
that.
The petition, I have done it, but
Don't do
file
this.
cover is being.
If
done
it
by
doesn't
the-
change the handwriting, you do it yourself. We will not tolerate this, madam. What is the use of deliberation in the court if you're not following?
I told him.
We may not
to
take up
write.
the petition.
I told him not to write in the.
Then has he done it?
I told him he's junior, he told that. he's
Has he done
junior.
it?
But I have not checked, lordship, but
Don't write something,
the-
scribble something and put it before
in
the
the
court.
entire petition, we have done it.
Why do you create this kind of a
Archive.
situation? Do you think that we like this thing to be repeated again? We don't get any pleasure in repeating this. This is basic, something you are presenting to the court, do it in a presentable manner. You scribble something, can't even decipher whose name is written. Is this see? Yes, what is it?
Impugn order is at page 30, lordship. 26/11/2025, lordship. His parents' name is there.
Right, slowly.
What are your grounds?
Grounds only discrepancy in the age, lordship. Otherwise, his parents, his father is there in 66, 70 and 97. His name is there along with his father.
What is your age?
Age is 51.
51. That means you are around 74, 75.
Yes, lordship. 97, his name is there along with his parents. And same village, lordship.
Heard, Miss D. Ghosh, learned counsel for the petitioner, who is aggrieved by an opinion dated 26/11/2025 passed by the learned foreigners tribunal number 4, Gwalpara, in FT case number 7, sir, whereby the petitioner has been declared a foreigner post 1971, full stop. It is contended that the opinion is based on some minor age discrepancy by overlooking the other relevant materials which were in favor of the petitioner. Full stop. Para. Let notice be issued, returnable on same date. Call for the records.
FT4 Gwalpara, lordship.
I have said, who will be accepting, madam? Year 4, Union of India LDV, then
Yes, 2, 4 and 6, I would be appearing, lordship.
2, 4 and 6,
7 also.
2, 4, 6 and 7. Then 3, M. Sina on behalf of Eskotoki. And 5 is P. Sharma, State Council. Okay. Extra copy that was given. Miss Ghosh, what is the date?
26/11/25.
Learned Counsel prays for an interim order, which however is opposed. Taragut Kuba submits that the petitioner is yet to be arrested and prays for an interim order, which is Tasa date to Kodib. You appear on or before, same date?
Yes, lordship.
Kutu date Kuchile Matro?
21.
21st, 20,000. Which border?
SP Gwalpara, lordship.
SP Gwalpar, SP border Gwalpar.
Deep blue, right?
You take your, instruct your, or change, write yourself. Yes, Mr. Chakma?
Yes.
How do you present this? These are your responsibilities.
Right, slowly.
I will take care of it.
And you can.
Right, whatever you write in a presentable that it can be, it is legible. We cannot read even.
Give them.
18, yes, what is 18? Yes, Mr. Sigdar. Let him do, let him do.
Impugn order we are challenging is in page number 86. Order is.
Why are you late in coming to the court? You are satisfied with the opinion, it appears.
For financial hardship, they cannot come sooner after the delivery.
Where have you stated? That for financial hardship, we could not approach the High Court?
Lordship, paragraph number 19, page number 20.
Please read.
That the petitioner begs to say that she is hailing from a poor family of remote village and she has in the family of no one to support her financially. She has somehow collected a minimum expenditure to file the writ petition. As a result, delay has caused in filing the writ petition. The delay so caused is not intentional and may be kindly condoned for end of justice. Lord.
Madam, we issue notice, yes. Heard? Huh? What is it? What did you show? Oh, okay. Heard, J.A. Sigdar. We record his name? Is it okay? Or if you want, we can record your name, whatever is. Heard, J.A. Sigdar, learned counsel for the. See, nowadays everything is in public domain. The client may ask you tomorrow, why haven't you appeared? So that is why we are giving you the option. If you want, we can record your name. If you want, you can record his name. Heard, Sri J. Sigdar, learned counsel for the petitioner who has put to challenge 4/11/2023 past insurance. It is contended. What are your grounds? Grounds of challenge?
Lordship, grandmother is voted in 1966. After that, her name is not been recorded with her father, but her father name is recorded in a Jamabandi with his
It
grandfather.
is contended that relevant materials have been ignored while coming to the impugned decision. Para, let notice be issued, returnable same date, huh? Miss L. Devi, CGC for 1, A. Verma for 2,
4 and 6.
2, 4, and 6. And 3 district commissioner is the P. Sharma. And 5 is M. Kolita on behalf of AI Ali for 5 ECI. Extra copies. The upset call for the records. Tribunal. Which is it? Sigdar, the learned counsel prays for an interim order, which however is opposed by the learned counsel for the respondents, who has also raised an issue of maintainability on the ground of delay in approaching this court. Para, considering the above, comma, and by balancing the equities, comma, it is provided that till the returnable date, the petitioner, no steps be taken for deportation of the petitioner, full stop. The maintainability issue is however kept open.
Obliged, Lordship.
Yes.
Lordship, the opinion is it is 112, starting from 112, and the opinion was dated
29/5/26.
29/5/2026.
What are your grounds?
My ground is that, Lordship, I adduced evidence along with my father who corroborated my evidence.
What is
before
your
the court.
age?
My age is 50 years around.
50 years.
Yes, Lordship.
You are voting, where is your voters list? Which one is the first voters list?
Voter list, Lordship, my voter list, Lordship.
First, when are you born?
I was born in around 1975.
75.
Yes, Lordship.
So your first voter list is of which year?
First voter list is of 1997. Lordship.
96.
97, Lordship.
97.
97 certified copy of 97 is available, Lordship.
Now, did you prove it
Yes.
before? You proved it.
Yes, Lordship.
This voter list has your father's name,
No.
husband's name.
Has-
So what is your link with your father? Since you are born post 1971, there has to be a documentary linkage with your father.
Document was given, Lordship. One Panchayat certificate was brought into record.
Panchayat
But,
certificate.
Yes, Lordship.
Proved by whom?
But that was unfortunately not proved by the council.
Even if
No
it is
advice was
proved,
given,
even if it
Lordship.
is proved, that will not be a conclusive evidence. That is the law. Any other document?
Other document, Lordship, her Gauhati certificate is there.
Gaumura, who has
it-
proved?
And in this case also, the council did not take any step.
Gaumura certificate not proved.
Not proved, Lordship, unfortunately. But the
So
evidence.
we adjudicate
the-
on what issue? If you
Lordship,
do not reduce the evidence and you put a challenge to the opinion,
Lordship, her father deposed and he corroborated. Her father's name is in the actually voter list of.
the oral evidence of the parent will it be enough in the context of the settled law?
In the context, strictly speaking, not enough, Lordship. But if it corroborates, then.
Corroboration
under
by
section
what?
50,
No, 50 is in a different context.
Lordship.
50 we have discussed in a number of cases, Evidence Act 50. That's in a different context altogether.
Yes, Lordship.
You read 50, suddenly 50 has become the matter of discussion in these cases. It is not relevant at all.
Lordship.
Can be corroborated.
It's a different matter, not for a determination of citizenship. It's a dispute within the family when a third party says. If you read the language of 50, please read Evidence Act. You have the Evidence Act. Please read.
I've not brought it today, the act, Lordship.
You read it.
Lordship, I showed it.
It
But,
is,
actually, Lordship,
it is not by oneself. It's when a third party gives evidence, then he can say about the relationship.
no submission at this point of time, Lordship.
No, we are not,
kindly put it, Lordship.
Dismissing your petition at the
No,
threshold. We
Lordship,
issue
Lordship.
notice, it's a matter of citizenship. We are aware. Important issue, but we have to come up with some definite grounds,
Actually,
sustainable grounds, which may require a deliberation, isn't it?
and, actually, in this case, what happens is a poor illiterate lady, Lordship. She relied on the council. But unfortunately, I have gone through the records. The council did not take any step, unfortunately.
You
And she is putting-
reported this matter to BCI.
No,
not-
Lordship, I have stated this in that.
You take certain steps against the council. At
But
least,
no step was found taken here in, actually, as per my record.
no,
So I do not know
you,
whether there is any petition in the record or the TCR. I do not know, but it
no,
will be informed.
not steps
Lordship.
by the council, steps against the council.
No, I have not taken any.
You could have taken steps if the council neglects in defending yourself. You have this step.
Actually, that is often happening in such cases, Lordship,
Okay.
that after examining the.
You are Zaid Hussain.
Yes, Lordship.
Heard Sri Zaid Hussain, learned counsel for the petitioner, who has put to challenge an opinion dated 29/5/2026, passed by the learned Foreigners Tribunal 4th, Darang, Mongoldoi, in FT case number so and so, whereby the petitioner has been declared a foreigner post 1971, full stop. Para, amongst others, the learned counsel for the petitioner has contended that the evidence in record, including the deposition of the father, have not been taken into proper consideration. Para, let notice be issued, returnable on, he did this, 14/9, huh? 14/9. Miss CGC, S. Thunder, you are a CGC, S Thunder for 1, CGC, huh? 2, 4 and 6, Miss A Verma, 2, 4 and 6. And ECI, M Sinha on behalf of S Kotaki, Standing Council ECI for 3. And 5 is by P Sharma, State Council, extra copies, huh? And call for the records of the learned tribunal, registry to do, registry to requisition the same. Full stops. Then you write 3 Hussain, the learned counsel for the petitioner prays for an interim order, which however is opposed by the learned counsel for the respondents. It is also submitted that the petitioner is yet to be arrested. Then the last paragraph we have given. Then date of appearance is 21st August, and bond is of 20,000. 20,000 and SP border, which one district?
Dorong Lordship.
Dorong district. You appear on or before 21st.
Obliged, Lordship.
You have that paragraph, no? Earlier paragraph. Put it in a draft will see. Huh? One? How many? 22 kilograms. 22. Please. Mr. Das, which you are for which matter? We'll be doing the, no, we have left out some matters in the beginning.
Okay.
Those we'll take for disposal. Yours is a what matter?
20 item.
20 is for what?
20.
Implement.
Implement. Yes.
Implement, we can do the matter, implement.
Yes, it's a very small.
Then we go back to the motions, the old motions.
Page 20 has already been served upon the.
20, page 20 already been served in IA 1067 of 2020.
You want implement?
Yes. This is an APSC case also. The commissioner secretary has been transferred. The new incumbent has come. That's why we filed an application for implementing. Notice was issued on 11/3/2026 at page 11, page 12,
January, January, page 12.
page 12.
These are APSC matters.
Yes.
Okay, let it come before another bench. Somehow this bench is not, least before. This before any other bench without one of us bracket of money.
Okay.
May I please? Lordship, I am for the second time before your Lordship. Now I am challenging the order which is ex parte one, but before coming to the impugned order, may I take your Lordship to the facts chronologically for easy access of the Honorable Court, my Lord.
Yes.
Staplers.
S. Chanda. Hyder Ali.
Hyder.
It was past expert.
Yes, my Lord.
Date of the opinion.
Date of the opinion, my Lord. 20/12/2018.
Page.
Page 60, my Lord, 60.
Which FT?
FT Jorhat.
Number? 21.
Only 1 month.
What is your date of birth? It's an ex parte order.
Ex parte.
Madam, it's an ex parte order. No, the opinion which is presently before us. Is it an ex parte order?
Order dated,
Lordship petition appeared,
order dated this one,
order dated 2012-18 Lordship.
2018.
First of, the first time he approached this High Court, that was an ex parte order Lordship.
Hmm.
Then was demanded.
Just a minute, madam.
not appear the second time also.
এপিয়ার কৰিছিলে কৰাৰ পিছত
Fights to go on.
মোক ক'বলৈ দিয়া নাই আপোনাক সুধিছো সেইকাৰণে মনে মনে আছো Paragraph 4.
Yes.
Lordship, before going to the other documents, my lord, may I take your lordship to page 48, my lord?
48.
48.
First, we can read the opinion first. I think
My lord.
matters will be clear. Page 60.
Page 60, my lord. May I read, my lord?
Yes, please. Mr.
On a
Arvind.
reference being received from the competent authority, this tribunal therefore registered a case being FT 428 of 2025, in which a notice was issued calling upon the said OP to appear and also to file his written statement. The notice issued to the said OP was served by hanging, stroke pasting of the same in a conspicuous place, and as such, the notice was duly served as per section 35G of the FT Order 1964. However, it appears from the record that on 3/3/2008, an ex parte order was passed declaring the OP of the case as a foreigner of post 25/3/71. Being aggrieved, the petitioner thereafter moved before the Honorable Gauhati High Court by filing a writ petition being WPC number 782 of 2017, in which by an order dated 14/2/2017, the ex parte order dated 3/3/2008 passed by this tribunal was set aside. By the said order, the said Honorable Court has also directed the petitioner, namely MD Haider Ali, to appear before this tribunal on 15/3/2017 at 10:30 a.m. along with his written statement, for short WS. Whereafter it was directed that the tribunal shall proceed with the reference in accordance with law. I have carefully perused the said order of the said Honorable Court. It appears from the records that by an order dated 14/2/2017 passed by the Honorable Gauhati High Court in WPC 782/2017, the OP, namely Haider Ali, was directed to appear on 15/3/2017 and to file his WS on the said date itself. However, though he appeared but prayed for time for filing WS, the Honorable Gauhati High Court by the said order also directed that if there is any default on the part of the petitioner either on 15/3/2017 or on any subsequent dates, tribunal would be at liberty to pass appropriate order in accordance with law. On 15/3/2017, though the petition was allowed fixing another date 6/4/2017, but in terms of Honorable High Court's order as above, my predecessor in office ought not to have fixed another date for the WS of the said OP, because he was directed by the Honorable GAC to file his WS on the date of his appearance itself, that is on 15/3/2017. However, from 6/4/2017 till 2/10/2018, there is no order been passed. Resultantly, a fresh, especially prescribed notice was issued to him, giving him a last opportunity to file his WS positively on 25/10/18. On 25/10/18, the OP of the notice returned unserved, for which a fresh specially prescribed notice was issued on him, which was received by the said OP personally from the office of this tribunal, duly witnessed by the earlier engaged learned counsel of the said OP, who is representing him even as on today. The notice therefore duly served as per the law, but OP of the case is absent today without any stay, compelling this tribunal to pass appropriate order as directed by the said order of the Honorable High Court. Thereafter, the case was posted again on 13/12/2018, but the said OP has again failed to appear and also failed to file his WS, for which the case is posted again for ex parte order, for which the date is fixed today, that is 13/12/2018. This being the position, I therefore don't find any justification to delay the proceeding for want of the appearance of the OP for his WS. Hence, filing of the WS is hereby barred, fixing on 20/12/2018 today for passing the ex parte opinion once again. Considering the order of the Honorable Gauhati High Court as above, although it is directed that no further time shall be granted by this tribunal for filing his WS, yet for the ends of justice, many other opportunities were granted to him for his appearance and WS. In view of the direction of the Honorable Gauhati High Court as stated above, it appears to me that despite having reasonable opportunity being granted, the opposite party has failed to appear and file his WS within the time as prescribed him so to do. As such, having no alternative, I therefore constrained to take up the case again for passing the order in ex parte. Accordingly, the instant case is heard and decided in ex parte against the opposite party herein. More so as required under Section 9 of the Foreigners Act 1946, the burden to prove that he is a citizen of India and not a foreigner lies on the proceedings. The present OP therefore absolutely failed to discharge his mandatory burden to prove that he is an Indian citizen and not a foreigner. The allegation as made by the state, that is referral authority, to the effect that the OP is a foreigner who illegally entered into the territory of India, Assam after 25/371, therefore stands unchallenged and unrebutted. Considering the matter in entirety, I therefore hold and give my opinion that the OP, the case namely MD Hyder Ali, son of MD Isu, present resident care of Sri Pitambor Borgohai village, Nitai Naujan, under Dimo PS in the district of Shivsagar, and permanent resident address Senimari under Bagpara PS in the district of Borpeta, is a foreigner who illegally entered into the territory of India, Assam after 25 March 71.
Yes. Yes.
My lord, I am a resident of Borpeta, my lord. I am a semi-literate in the sense that I write only my name. I have no schooling education. I cannot read and write, except writing my name only. For livelihood, I went to Shivsagar and Jorhat way back in the year 2007, my lord. Thereafter, after some days, I returned back. A foreigner proceeding was proceeded against me there, but finding me absent there,
Where? At
at
Shivsagar?
Shivsagar. And it was proceeded ex parte and I am declared a foreigner. Subsequently, the said order was a common ex parte order, my lord. A group of persons, they were declared foreigner as an ex parte basis. Upon coming to know about the said ex parte order, I approached before this honorable court. Your lordship will find the said order at page 48, my lord.
No, those we have seen, those details you need not again
Yes, my lord.
reiterate. The first ex parte
After-
order was set aside by this court
Yes, my lord.
on 14/2/2017.
With a direction.
And while interfering with the ex parte order, there were certain conditions.
Yes,
First condition was to appear on 15/3/17
with the.
and file the written statement.
Yes, ma'am.
You appeared on 15/3/17,
My lord.
but you did not file written statement.
My lord.
You rather filed a petition seeking time.
Yes, my lord.
Time was granted to 6/4/17.
On 15/3, I personally did not appear, my lord.
Understood? Time was granted to 6/4/17.
Yes, my lord.
6/4/17 to 12/10/18. Almost how many? More than a 1 year, half, 1.5 years.
year.
1.5 years. There was no orders passed.
No order passed.
Then fresh notice was issued directing you to appear on 25/10.
My lord.
That notice returned unserved. Okay, this unserved.
My lord.
So it may be your case that I was not aware of this, the fixing of date. Then on 25/8, when it had returned unserved, notice was sent in presence of your counsel,
My lord.
fixing 13/12/2018. You did not appear.
My lord.
And finally, it was fixed for passing ex parte opinion on 20/12/2018. So on that, it has been passed. So
My
what are your submissions?
My submission is that as per the Honorable High Court order, I appeared before the tribunal and engaged an advocate. And I handed over some documents which were in my possession. After going through the records, he asked me to obtain other
Mr.
certificate
Alim,
copies.
you cannot proceed further. You did not abide by the High Court's order first.
My lord.
You did not file the written statement. You cannot take advantage of your own wrong.
My lord, my lord.
If you have not abided by the High Court's order, whether you have deposed, you have submitted some documents before the council or not, those are internal matters of you and the council. You were equipped, you were rather armed with an order of this High Court of 12/14/2017, directing you to appear on 15/3 along with the written statement. You failed.
My lord, kindly consider one thing that I am an illiterate person. I engaged an advocate and handed over documents.
The moment you are armed with a High Court's order, you cannot take the plea of an illiterate, being an illiterate person. Your matter was handled in the High Court by a counsel.
My lord, for a moment, kindly come to.
Why did
page
you appear?
8.
You are an illiterate person. You do not even know when to appear. You appeared.
And I handed over the documents. and
That explanation will cannot.
My lord, kindly consider that I
No,
have
we have
made
been
the
passing,
concerned
see,
advocate as a
Mr.
party here,
Alim.
my lord.
Mr. Alim, we have been passing orders of this nature in and out. We interfere with ex parte, but we give an opportunity to appear and file written statement along with evidence. What is that done for? Because that is in terms of 1964 orders. It has to be completed in 60 days. Now a matter which started in the year 2008, you have been successful in dragging to 2026.
My plea herein is that. the
Mr. Alim,
concerned
that will not
advocate-
do. We are a court of equity. We cannot shut our eyes to these practical aspects. Either this way or that way, marriage. We are not at this moment, we are not on that.
My lord,
We are on the conduct of yours.
I admit that there are loopholes on my part.
Not
also.
loopholes. You fail to abide by the orders of this court.
But circumstance leads that, my lord. Kindly come to page 8, my submission, my lord. The concerned advocate consoled me that the written statement will be filed.
Okay, we'll take this into consideration and we'll reject this.
My lord, kindly
We'll reject
consider one thing, that I have all the documents, my lord. Only I could not
You
produce
cannot be
those.
successful in dragging a matter now. You can drag it once, twice, not all the time.
That is true, but my lord, kindly consider that my citizenship is at stake.
Yes, yes. You have been very, very shrewd in dragging the matter from 2008 to 2026.
But the tribunal, the matter was kept without passing any order.
We give all the fault to the tribunal. All the fault. But the main aspect which arise on compliance of the order of this court of 14 to 2017. Had you filed your written statement, then a matter had gone off track and later on you are not noticed, then we could have taken a different stand. It might happen that you file written statement, matter goes off track, thereafter lawyer does not inform you, and whether you have been put to notice or not, we do not know. There may be a case. You paid for time, time was granted.
My lord, time is granted.
And the subsequent member, in fact, he was not very happy. He was slightly critical whether he could have done so or not, but he did not do away with. Yes, time was granted. Okay, it should not have been given. Time was granted, but have you filed a written statement? No.
How I am barred by the written statement, that could kindly be considered. my lord.
Too late now.
On the first date, I was sick, my lord. Thereafter, I document handed over to the council, engaged counsel. He said that.
Say from 14 to 2017 till 15/3/2017, it was 1 month. The High Court was magnanimous enough to grant you 1 month's time, not to appear, but to file your written statement.
On 6/4, no order has been passed. The record was missing, my lord.
No, not on 6/4, on 15/3 we are asking about 15/3.
On 15/3, I was sick, my lord. I have specifically stated in my petition, my lord. Due to my sickness, I could not appear. And on behalf of me, a petition was also filed. Kindly consider one thing, that the Honorable High Court's order is subject to some, my lord, exceptional circumstance, my lord. As a sick person, I could not appear from Borpeta to Jorhat, my lord. That kindly be considered, my lord. And accordingly, the same was allowed, my lord. But on 6/4, my lord, there is no order, my lord.
That we know, that is the fault of the tribunal. But before we go to the fault of the tribunal, we have to examine your conduct. It's an equity court.
Now, my only submission is that since I have the documents, one opportunity may kindly be given to produce.
Again, tomorrow we'll file an application for adjournment.
I undertake not to repeat.
No. That undertaking we are not going to take. We are not going to take that bait. Somebody had taken the bait and he suffered. System suffered. We will not allow the system to suffer like this.
Had it been so that I do not have any document in my possession, that is separate matter, my lord. I have all the documents. I have annexed here in my lord. Clearly proves my citizenship, my lord. On the face of the record, my lord. I admit all my fault, my lord. My only prayer is that one last opportunity may be given, my lord.
That last opportunity, you have missed the train long time back.
That I admit, my lord.
Train has gone somewhere, reached somewhere.
Since the conducting engaged counsel did not do it, I have made here in party, my lord. Yet after taking the fees and brief, she did not prepare the WS, my lord, and submit it before the tribunal, my lord. I have made also averment before this court, my lord.
Where are the records? Ten. It's called 68. It's mentioned as 68.
68 is mentioned in the order sheet.
Hmm.
And the improved order case number is 420.
Yes. No, here in the notice it is 68. Earlier and that maybe the number might have changed. Huh. Still it was not filed. Okay. Very weak case. Yes, madam. Anything else? Anything else? That's all right. That's all. Page.
Page 56.
Order dated.
Ex parte order was passed and written down.
Hmm.
We had so much urgency. This case was listed in 2019. All two lordship directly got a adjournment before the High Court. They never been serious about this matter at all. I checked his case records this morning, lordship. And get done. Reason only today.
No, probably not in the High Court. Probably not in the High Court.
There was because
No, probably not, because this matter, this High Court case was registered in 17 and the order has been passed on 14/2. They could not have been.
20 was listed at least 6-7 times.
Oh, this one. This one.
This matter.
Yes. This matter, the appendix is 18 that we did not even urge. Earlier matter was not pending.
Yes, not the earlier.
This obviously 2019 onwards is pending.
But it's here, this is only today. Because I was come before the mention before the. I have to go. This matter may be not wrong.
That will not find fault with it, that is one of the system. Yes.
Opportunity was granted to him. Sufficient time was given to him. He is supposed to sit behind and relax till this court passes an order to for remand back again. He has missed the bus not once but twice.
No, magic you are not entering right now. Only on that aspect of delay. Madam, what would like you to address us or any of one of you, the Ali? It's an equity court while deciding a case. If there is a party who has failed to comply or abide by the orders of this court on the earlier round of litigation, how much audience he or she would be entitled to on the aspect?
Remand not be understood as a approval of the contract of the.
Yes,
application before
that has been said.
Hmm.
No, that, Sabita, we have read that. We know that. No, we are on a different aspect altogether. We are on the aspect that the earlier order of the score of 14 to 17 was a conditional order. High Court has no doubt interfered with the earlier ex parte opinion, but while interfering said that on such and such date, you have to appear with a written statement. He did not comply with. Having not complied with, if he comes to the High Court on a second occasion, being an equity court of equity, how much ground or audience he'll be entitled to on this aspect? If you do not approach the court with clean hands, to be put in a different expression, how much entitled you will be entitled to from a court of equity? No, we are not fixing up tomorrow. We are on this aspect, equity aspect. You to principal, one who does not do equity will not be entitled to. Okay. English shape I said. If you just immediately to raise the right, there is an immediate conflict. English English course of equity. Coming with clean hands in the characterization. On wrongdoer will not get the benefit of a court of equity. Cannot take advantage. Don't expect equity have to come with diligence and clean hands. I got on. You cannot take advantage of your position. Latin eight. One who seeks equity has to do equity. That is the principle.
But available as an instrument to report submission of. And have to put this judgment structure.
Yes. He who seeks equity must do equity. Yeah, anything, Mr. Ali or Mr. Sharma? To in continuation with Madam Verma?
He should have approached before Somnayan court. In the justifiable ground that why he could not avail the opportunity given by Somnayan court in the earlier petition option. And that the media will allot by against him. Even in the after that, the expert order was passed. Even though this is not a strict civil proceeding, but the procedure of the civil court is generally followed. So once a person is given the time to file evidence statement, because it's easy to file even after 30 days, an extraordinary time of 90 days is free. It's not every day opportunity without giving any sustainable result. When he was opportunity of filing evidence was closed, he never approached this court in time, seeking opportunity when explaining the reason why he failed. Only after the expert opinion was again passed against him, he came for his honor.
There is one more aspect which we have taught. The 64 order also provides for an opportunity to set aside ex parte. When there is an order to proceed ex parte, we are not talking about the opinion, ex parte opinion of 2012-2018. There is an order of 13-11, 13-12-18 to proceed ex parte. 13-12 could have been applied to be vacated.
Yes, that is always there.
That is a provision of law which has also not been done.
There are two possibilities. Two options are given by law.
Yes. Okay, we close this. Madam, give some judgments. But Mr. Alim, difficult. Heard. 3. S. Alim Learned, counsel for the petitioner. Sab likh rahi, huh? The hearing is completed and the judgment is reserved. Give the judgment by tomorrow or if not at 2 o'clock, along with the paragraph numbers. Okay. You can do one thing, madam, or whoever gives. Only those paragraphs, take photocopy of those pages only. First page and those pages which contains the paragraph you are referring. And please mention the paragraph on the first page. No need of the entire judgment to be photocopied. Okay.
And take it out.
We can verify. Itu ya dia dibuka dulu ya dia di sini.
Aduh.
Orang itu tu.
I will not.
Huh?
How about burden?
Ini begitu besi burden nalo.
No. I'll say.
Yes. Yes. What kind of instructions?
Security order.
Hmm.
Who has the order sheet? Dictate it first. Then my name, what is the case listed? That from the reference, all the record, showing the name of the dealer. But my name is zero. And all the documents I have annexed. My name is zero. My name not here, there is a D mark is there. So obviously there is a case in there. So when this notice is tendered to me, Lordship, I also refuse to accept. As because of my name is not valid. And ultimately, Lordship, with security order. As because of my in some of the hotel which I had annexed, when this man as a deep hotel, and till date, Lordship, it is a true Lordship. Till date, I have not trusted my court Lordship. So in my name, Lordship, obviously another case is there. So I am waiting for notice for that case, Lordship, in my name.
But it is such a coincidence that husband of both the ladies is Kandura. And you know why his name is Kandura? Because he has 2 wives. Therefore, he keeps on crying. Kandura Sheikh. Huh? It's difficult to accept. You have 2 ladies, but your husband is the same. Different husbands, but name is the same.
Yes, sir, I will be difficult. I will face the difficulty. Because my name's case is there. Demand is there. Case is obviously there. Then day after tomorrow, another notice will come in my name.
We'll clarify that. We'll clarify that. That difficulty will remove. That once you are declared a foreigner, you will not be declared a foreigner in another case. Happy?
Why these all the documents, my name not be considered. Going on Javiran, and what she said,
That is what is most intriguing. Both, you have both husbands, both the ladies. Husband has a common name, Kandura Sheikh.
That is Jabiram Deva.
the case was, yeah.
Show it to Madam and Mr. Sharma. What is this?
That say that I have not that there is every that case is that's because I am not that person. I am not that person. But I am some barely submitting everything that from the reference to sustain to this safety is not mine. And mine I have it is part deep I have a deep. So in mind, and they have to for another issue. So that's why the discussion was sort of whether another case is pending or not.
Separately.
Separately.
That's right.
Common submission. Very common submissions, where just B becomes B becomes P lordship, and the name changes. They can take up this P before the tribunal and let the tribunal pass its opinion.
Which tribunal? Tribunal already passed. So where is there? Okay, your instructions, okay. Which paragraph, madam? Okay,
Para 7. I think. Yes, para 7. Para 7. Inclusion of the. At the time of verification,
From the verification of the way before, I could have said that not knowing what they will do it and
it was actually. Short status.
then we can record his submission, and on the ground of Lucas we dismiss and we say that in accordance with law you proceed. But we'll not say that she is not this person or he is not. We will only say.
That we do not have enough materials to say this at this stage.
Submission actually not doing, not accepting the notice.
Later on the case is for the
Final
declaration.
Cannot accepting the notice.
You are Maziran or Jabiran? Zabiran? Maziran, not Jabiran. Let us see the documents.
Case 13,
The tribunal's order.
page 28. Page 8, that is reference case 21.
2-1. Yes.
One.
Yes.
Javiran Bill. You claim your name to be Maziran.
My documents is very good. And the next
All are Maziran.
B-E-O-B. You.
In this 55, there is. 22 is the this type of lordship. It is also natural for.
You claim yourself to be Maziran. M.A.? Okay, we take a break of 5 minutes. What are your, this is an expert order. What about the village? Same. Where are your documents? Other documents? Item number 22. Page 13.
This is the purpose at the time of the penalty. Now, this case of
25. What? This is not even a certified copy.
Yes. Yes. And this also my name is there and the Gmail is there.
So how do you resolve this, madam? See, he has got certain documents. It's an expiry order, so there was no opportunity, or rather that scope or. Yes.
No, the notice came in the name of Jabiron, and she said, no, that can be, theoretically that can be, theoretically that can be. But that is understandable because people.
So there may be many, yes, as you have just submitted. This would not be the, or may not be the only case of this nature. So what is the resolution? How have you tried to resolve this kind of a situation? See, here there is a reference in the name of A. He says that he is B.
B.
And therefore B has not taken the notice of A. Though it appears that A and B is the same person. Somehow B was written as A. But he did not go to the tribunal and say that no, notice has come for a wrong person, though the husband's name is same. But for that, can you put the entire fault on him? That's one question we are just discussing. So, and it's also a fact that B has a D attached. So that way B is also not free. B has to face a proceeding. But proceeding has all along been in the name of one person whose name he differs, apparently differs, and therefore he has chosen not to contest. Why should I contest? It's not my name. So can we resolve this by setting aside the ex parte and to do substantial justice, have the notice in the proper name? Because these otherwise, proceeding otherwise have to be initiated and concluded. I think that.
After verification, yes. After verification, the reference may be
If
made in
there
the
is
upward-
any other resolution, mode of resolution or any other precedent in this situation, you kindly enlighten us, we'll try to consider that. We think would be a possible thing, which will also be amounting to give him a chance. This controversy of Jabiran, Maziran will be settled. And we'll follow this 1964 that 60 days will follow. But one thing again arises, Mr. Hawk. The direction of this court, of course, 226 powers are there, but there is no reference till now in the case of Maziran. How do you take care of this? Please go through once properly. We have another copy. You can go take this copy. See, it is very easy for us to follow what Mr. Hawk has said, that earlier writ petition dismissed on the grounds of locus, but that will not bring an end to the matter. He'll still have that defense. আমি clarify করেছি 226 Fresh reference against fresh proceeding by construing Maziran to be Jabiran, because all other particulars are the same. And the D is also there. Huh? Educate proceeding is seen because this D is the mark code.
references come in the name of
A, who's the wife of B? He's the same address.
During the course of the proceeding, they will decide this issue of identity issues. Part of the
money say, but the duty liquidate ভুল হয়েছে, Jabiran Maziran বলেছে। আর Maziran হচ্ছে D আছে কিন্তু। It should have been Maziran. Taking into consideration all other factors are the same, particulars of husband, the house, Jabiran only because Jabiran is Maziran. Let it be conspicuous Maziran and proceed. No matter we proceed, in other words, if there is D within 1 month. That is the custody is 43. But we get the full scope, no?
on that point also.
No, on this point only আমি Jabiran number টা নেই। বলো, আমি একটু ক্লিয়ার করে দিয়ে দেবো। Maziran against একটা D একটা আছে। It's unanticipated. Maziran document to D একটা আছে। তো Maziran আর দুটো এডিট করেছে তুই দিয়েছে না এটাকে নিয়ে প্রসিড করে বলে পারি না
But the instruction is different.
My instructions were verified that the
If
Maziran and
they've stated something else. Yes.
each time. Call them up again and I'll explain it to them. I won't hide this time. Talk to them.
What they've stated is correct, that determination of the nationality is by foreign tribunal, but you had asked for a different instruction. You've asked for something else.
Whether any case is this,
That is very difficult for us to find out if a reference is pending. Find them out.
now what we were now what is our loud thinking is that see there is a reference in the name of Jabiran. He claims that he is Maziran. Other aspects are all the same, including the husband's name, address, everything is same. So it prima facie appears that there is a mistake in the name. At the same time, to fortify this aspect, this Maziran has a D prefixed. So Maziran otherwise also have to face a proceeding, if not today, tomorrow. So if we can resolve the issue by, and he has given a document which is yet to be put on record or examined by a proper forum. This is in a very unverified copy, but nonetheless, that voter list of 2005 has a Maziran with D. He may have other documents to show, to prove his her citizenship, which is for the tribunal to, which one? No, he's saying he's Maziran. Maziran. References was the name of Jabiran. He says it's been forced upon me. I failed. I did not go. Why should I contest? But taking into consideration the husband's name, address, and Maziran herself has a D. Maziran needs to face a proceeding, if not today, tomorrow, because with D you cannot vote. In fact, we have been dealing with number of cases. The D is there, but there is no proceeding. We said that you trace out and proceed in accordance with law. No, Mr. Ali, try to have a practical outlook of this. It is clear that there is a mistake in the reference. Even if you make a search or a verification exercise, there would be no reference to Maziran. Maziran has been correctly marked D in terms of the reference already made, but that reference, Maziran, was written as Jabiran. Only that aspect. That is very clear before us. If you want, we can grant you time to have the instructions, Jabiran number. Even if you do not get the instructions in view of this document of 2005, uncertified. No, we'll clarify. We'll clarify. Taking into consideration the husband's name, the address, it appears the reference was, let it be constituted to be Maziran, and he gets all the opportunity. And otherwise D is also there, he has to remove this D. Yes. Yes. We grant sufficient time. We grant him more than 20 days to appear along with WSN evidence, or even something more, because there is a name discrepancy. We can grant a month's time also. But from there, 1964, 60 days. Okay. That is not upon him. That is for the tribunal. We'll grant him a month's time. We'll clarify that. We'll clarify that. It cannot be true proceeding against you. We have been clarifying in all cases. Yes, please write. The instant petition under Article 226 of the Constitution of India has been filed, putting to challenge an opinion dated 17/1/2018, passed by the learned FT Dhubri,
FT number 8 Dhubri.
Foreigners Tribunal number 8 Dhubri, in case number so and so, whereby the petitioner has been declared to be a foreigner post 1971. Full stop. The primary ground of challenge is that the opinion is an ex parte one with the ex parte one. Full stop. Para. We have heard Sri I. Hawk, learned counsel for the petitioner. We have also heard so and so. Huh? This court wide order dated
11/3/20.
No, or record to call for. By order dated 17/12/2019 had called for the records of the learned tribunal which have been received, and We have perused the same para. 3. Hog the learned counsel for the petitioner by referring to the referral order dated, what is the date? Referral order 10/10/1997 has submitted that the proceedee is one Jabiran Bewa, Jabiran Beouya. No, this is not W. Beo. We have read. We have tried to read carefully. Beouya. Huh? See in the next part. It's very clear. On the other hand, comma, the petitioner claims her name to be Maziran, Maziran, Bewa, Bewa. Full stop. Accordingly, comma, when the notice was sought to be served, comma, the petitioner had declined to accept a notice in the name of another person, leading to the learned tribunal to proceed ex parte, and accordingly, the impugned opinion has been passed. Full stop. Para. The learned counsel has, however, submitted that from the documents which she has obtained, comma, in the voters list of 2005, comma, her name has been prefixed with D, and therefore it appears that there is some proceeding against the petitioner also. Para. On the other hand, comma, Ms. A. Verma, the learned standing counsel, Home and NRC, has submitted that though in the referral order, comma, there appears to be some discrepancy in the name, comma, all other particulars are the same, including the name of the husband and the address. Full stop. She submits that it clearly appears that there is an inadvertent error in recording the name of the proceedee as Jabiran Bewa, which should have been Maziran Bewa. Full stop. Para. The aforesaid submission is also endorsed by the learned counsel for the rest of the respondents. Full stop. Para. Section 902 আছে হ্যাঁ, এটা আমি কোট করে দিম হ্যাঁ। Para. In the instant case, comma, the records, a perusal of the records would reveal that the referral order was indeed in the name of Jabiran Bewa. Full stop. However, the name of the husband was clearly written, which is Kandura Sheikh, along with the address, which is exactly the same of the name of the husband of the writ petitioner and her address. Full stop. While the writ petitioner may have, while the writ petitioner had opted not to contest the proceeding, as apparently the notice was in the name of another person, comma, we are of the opinion that since admittedly, comma, there is also a fact that D has been prefixed in the name of the petitioner as revealed from the voters list of 2005, comma, the petitioner is also required to prove her citizenship in a proceeding before the appropriate tribunal. Full stop. Para. Taking into consideration the facts and circumstances, including the aspects that the name of the husband of the petitioner and her address are identical to the proceedee against whom the proceeding was initiated by the referral order dated 10/10/1997, comma, we are of the opinion that interest of justice would be served if the ex parte opinion dated so and so is interfered with and the present
petitioner is allowed to contest the same by appearing and filing written statement along with producing all her witnesses, full stop, para. At this stage, comma, Sri Hawk, the learned counsel for the petitioner, has expressed an apprehension that there should not be another proceeding on account of the fact that D has been prefixed with the name of the petitioner as appears from the voters list dated 2005, full stop, para. By balancing the equities and to do substantial justice, comma, while the ex parte opinion dated so and so, passed by the learned so and so, is set aside, comma, the petitioner is directed to appear and contest the proceeding by filing written statement and also the evidence on affidavit of all her witnesses, full stop. Let the date be fixed before the learned tribunal on on 11th of September, okay, 11th of September 2026, and on such appearance along with the conditions mentioned above, comma, the learned tribunal shall take charge of the proceeding and proceed in accordance with law and by following the prescription as laid down in order to rule 14 of the Foreigners Tribunal's order 19, what is the name of the order? 1964, isn't it? Foreigners Tribunal, 214. Yes, Foreigners Tribunals Order 1964, 214, huh? 214, no, is it? Right, wait, yellow. Not 2, 3. 314. 314. Full stop. To clarify the matter, comma, the name of the proceeding which has been written as Jabiran Bewa is to be construed as Maziran Bewa, and on completion of the proceeding, comma, no further proceeding against Maziran Bewa is to be instituted. No, we have already said. We have said
Treating her as
construed as Maziran. First, the records be sent back forthwith. I think this will take care of the matter. She also gets a fair opportunity.
potentially
Yes. Records are there, madam. Records are there. Okay. Not ex parte. Okay. Mr. Alamgir, just 1 minute. opinion, date, name of the proceedee, Srimati Sachi Rani Das. At the outset, we put you this option of CA. Are you agreeable? State government is vigorously trying to settle matters under CA. If you are agreeable, we will not go in deep into the matter, because there are few matters which we have come across on the ground of CA. We remanded and we said that you decide on merits. State government had filed an application that these are CA matters, there is no requirement to proceed, and the proceeding can apply under CA. Then, madam? But in that case, we'll grant a liberty. In case the CA fails, then he can re-agitate this. Otherwise, he'll be put to prejudice. Because we are not interfering with the judgment, interfering with the opinion. Huh? Huh? Events of
Otherwise, how will we dispose it?
dispose of
with the observation that we will
observation approach, and if he
with the liberty.
if he he'll be
So again, on the
restored to file.
Okay, restore to file.
He can apply for restoration if it goes against him, because we have not will not be expressing any opinion on the merits. Okay. Heard 3 A.H. Alamgir, learned counsel for the petitioner. Also heard Ms. Savarnam Likiba. The present application under Article 226 of the Constitution of India has been filed, putting to challenge an opinion dated so and so 5719. Is it 5719, passed by the Learned Foreigners Tribunal number 7th, Lonka, District, Nagaon, whereby the petitioner has been declared to be a foreigner post 1971, full stop para. At the outset, there is a submission made on behalf of the petitioner that in view of the provisions made under the Citizenship within bracket Amendment Act 2019, the petitioner who claims to be eligible may be granted the option to make appropriate application under the said Act. Full stop. The Learned Counsel for the petitioner has, however, prayed for a liberty to re-agitate the matter on merits in case such application does not culminate in any fruitful results. Full stop para. The aforesaid submission is not opposed to in principle by the Learned Counsel for the respondents para. In view of the aforesaid situation, this writ petition is closed by giving liberty to the petitioner to apply under the CAA 2019 in accordance with law. Full stop. If depending on the outcome of such application, the petitioner, however, will have the liberty to file for restoration of the writ petition to be decided on merits if the situation so requires. Para? Writ petition accordingly stands closed. Yes, sir? Huh? After some time, on behalf of Arali. Huh? H. Ahmed. Okay, after a while. Please call him.
Identify.
All timing. Yes, call your senior fast.
Item 7.
Sometime. All timing. Okay.
Eight. Item 8.
Yes, madam. You want to avail CAA option? You want to avail CAA option?
Yes, citizens.
Hmm? একদম vigorously basically এগুলো মেরিট তো দেবো না আমি তো রন্ধনের মোটরে যে কন্টেন্ট হবো নাকি আমি আমার ডিসাইড তো করছিল মানে মই সেইটো ফিগাৰটো দিছো তাত আমি এটা বেটাৰ কথা দিছিলো যে আমি 40 দিব মনটো বেছি এইটো ল'ব নালাগে কাৰণ আমি এইটো কনচিডাৰ কৰি আছো ৰন্ধনটো ফচি গ'ল আমি কণ্টেম্প হৈ যাব বোলে মোক কোনো সিহঁতৰ পৰা দৰখাস্ত লোৱা আমি মুভি কৰি আছো Yes. Yes. Similar order we can pass. Okay. পুনমে মাৰি দিব পাৰি পুনমৰ পৰা লৈ ল'বা অকল এইটো চেঞ্জ কৰি What is your name, madam? MD Medhi. Miss MD. Are you on record? No. BC Das. On behalf of MD Medhi. On behalf of BC Das. And বাকি respondents of লিখিবা বাকি এইমাত্ৰ হেৰি লিখিছো আমি পুনমে লিখিছে exact order to দি দিবা We give you the liberty to approach, and if you fail there, you can still come before this court with a restoration. We are closing this, okay?
Item 9.
No notice is served. Just a minute, please. You are a legal aid counsel. Page 13.
Union dated 4/3/20.
Not 13, page 12. We propose to restore 5 by common judgment. What is the name of your client? Alauddin Haq.
Judgment was the 4/3/2005.
4/3/2005 judgment.
Again, it was said.
Under IMDT, you were, this is of which, no, it was after striking of the IMDT, this has been
Transferred to the foreigners tribunal.
after striking off.
It's transferred to the foreigners tribunal.
Okay. The judgment is of which date? Sarvananda Sonwal? Date? No, date.
Date of decision.
No, there we are. No, the date is there. Date is there on the top. No, not 6. 5. No, because this judgment is the 4/3/2005. So probably before delivery of. Because see, it is by the IMDT, not by FT. Listen.
Yes.
Where is the aspect of expertise? Which the paragraph? Declared. Expertise.
No, that will be force. Declared. Pending as a
তেতিয়া আৰু ক'লে হয়। এতিয়া যদি আমি expertise হেৰি তেতিয়া FT কৰিব আছে। এইটো challenge কৰিব লাগিব। No, once the proceeding has come to an end, FT will not have an argument unless that is said.
Declared it to be not a crime. Cannot be reopened.
Yes, which paragraph, Mr. Nath? That it was expertise? 1-3, yes. Yes. Now, regarding the aspect of issuance of notice, where is the discussion? Yes. Where was the service, which pair? Yes, first paragraph. Last 10 lines. On the face of the service report. Yes.
If some unknown expenditure after started less legal on the case of service people of the issuance of notices versus issuance of notices as subject to law. Service of this many copies that is respectively without no reasonable purpose and state brings then it we are totally decided to the concern of officer these cases it happens.
How did you come to know about this opinion? But Mr. Nath, there is also a responsibility, a duty cast upon you. No, Mr. Nath, there is a responsibility cast upon you that if there is a proceeding and if you leave that place, you are to inform. You cannot take advantage of going away from that place and saying that notice has not been served.
Yes.
The amount of effort the state had to give to trace you out and put you in detention, those nobody thinks about. You were put in detention in which year?
2016.
16, after 11 years. 11 years, efforts were there to know your whereabouts and ultimately put you in detention. Who will compensate the state because of these efforts? You did not inform that you had left the place, which was a duty cast upon you.
At the same time, Lordship may give me opportunity to establish my citizenship also.
That opportunity you will be entitled. Once you come up with a case that yes, bona fide reasons, I was not served. You left that place without informing anybody. Yes, madam.
Such bad cases, Lordship.
You're not saying anything?
Lordship,
We piloted that actually.
my submissions will again be the same. He's gone. He didn't inform as per the law, Lordship. And then he's before this court after so many years. Abuse of law.
He would come only after being taken on detention. When did you file this? 19.
19, Lordship.
This is.
19.
19.
You were taken into detention in 16.
16.
And during the pendency, you have been released on bail.
Lordship.
Now you are outside. Are you in touch with your clients? No.
Never talk with my client. Even only once long back when filing this case, before filing this, I talked with the jail authority and I request them to, can I talk with the client? They said, no, this is not permissible. I have very limited information to file this. When I filed this case, I was very limited information. And whatever information I got through the legal service. That's it.
Violated that provision. Inform about this. And significant times also involved in the process. Still just proof. But but evidence to defend. Like active proceeding now. State of
এই ক্যাটাগরিটা লেখুন This was required under the IMDP. Now these things are saying that in the name of foundational fact to bring back the IMDP.
All the facts now actually.
The issue of the reference itself gives you an opportunity to
need to require evidence.
Yes, what can be done, Mr. Adi? What can be done?
There's no connection with this client. I was asking him, how do you inform?
No, he's a legal aid counsel.
Whether his client is there or not, Lordship, there's no information.
He's on bail now. Now he's on bail.
Lordship. In the year 2021.
He's granted bail. Again, locating him will be not an easy task.
Now we can do one thing. See, but we do not know his whereabouts now. We set aside with the order. Tentatively, we are just thinking, and give a time. If he does not appear within that time, the order will be effective. Will be put into operation.
Revived.
And one more thing, my brother has pointed out that though the impugned opinion is an ex parte one, it was passed under the IMDT Act, wherein the burden was on the state. And only because it was an ex parte, it was simply not opined that you are a foreigner. Evidence was taken, just like a civil proceeding.
State has adduced evidence.
State's evidence.
Therefore,
And
it was
under that tough law, though it's an ex parte one, you are not given, you have been declared a foreigner. So materials are against you. Now, Under those circumstances, having declared you as a foreigner, the matter cannot be equated with another ex parte order passed under the present act after abrogation of the declaring ultra virus of the IMDT. We fix a date. If he appears well and good with documents and evidence, otherwise the order will remain effective. Okay.
He's unlikely to appear because you have no touch. And how will he come to know? You will not bother to find out, obviously. You will not bother to find out.
Communicate the legal service authority through the order, and they can communicate the concerned authority.
Maybe one notice to the
That is
location.
the only way.
One notice to the legal say put up now.
No, no.
We talked about
He
it.
doesn't have.
After the keep an eye on this one. That was hypothetically bail of Heard. Your Binath, Learned Legal Aid Counsel for the petitioner. Also heard Ms. A. Verma. Subharnam Likhiba, huh? The present petition has been filed challenging a judgment on order dated 4/3/2005 passed by the then IMDT. No, IMDT. Where is the opinion? IMDT Jorhat. In case number so and so, huh? Case to number to likhi diba. Where is the number of the case? In case number JDT 332/2008, 3 number 2, whereby the petitioner has been declared a foreigner. Full stop. Para. At the outset, comma, the Learned Legal Aid Council has submitted that the case was decided before the judgment passed by the Honorable Supreme Court in the case of Sarvananda Sonwal versus so-and-so reporter and so-and-so. And under the then IMDT Act, full stop. He has, however, submitted that 5 numbers of cases were considered to gather and disposed of by the common judgment dated 4/3/2005, whereby the petitioner was declared to be a foreigner and such judgment was passed ex parte. Full stop. The Learned Council has drawn the attention of this court to the observations made by the Learned Tribunal in paragraph 1, whereby the service reports had indicated that the petitioner had left for some unknown destination after the police had started inquiring, and accordingly, the Learned Tribunal, after considering such report, had come to a conclusion that substituted method of service of notice will serve no useful purpose, and accordingly, the matter was proceeded with. Full stop. Para. It may, however, be noted that as per the earlier IMDT Act, comma, the burden was still on the state to prove that a proceedee is a foreigner, and that burden appears to have been discharged by adducing of evidence of the relevant witnesses. Full stop. Para. Srinath, the Learned Counsel for the petitioner, has, however, submitted that during the pendency of this writ petition, comma, the petitioner, who was in detention from 2016, was granted bail, and thereafter granted bail. Full stop. He, however, also informs this court that he being a legal aid counsel, comma, is not in touch with the petitioner. Full stop. Para. Ms. Verma, the Learned Standing Counsel, whom an NRC has, however, submitted that the modus operandi adopted by the petitioner is only to evade the notice and evade the notice full stop. She has also highlighted the aspect that a proceeding is under our duty to inform the authorities for any change of address once the proceeding had started. Full stop. She has full stop. Para. She has also submitted that remand of this case may not serve any purpose, as the petitioner who is on bail is as the learned counsel appearing for the petitioner, he is not even aware of his whereabouts. Para. After considering the facts and circumstances and the records and on perusal of the records of the tribunal, there is no manner of doubt that the judgment, so far as the petitioner is concerned, is an ex parte one. Full stop. The learned tribunal had, however, come to a conclusion that though notice was attempted to be served, the service reports had disclosed that the petitioner had left for some unknown destinations without any information, and such leaving was after the police had started inquiring. Full stop. Though the learned standing counsel may be right in contending that the petitioner may not be entitled to an equitable relief, as no information was given to the authorities before migrating to some other place, we are of the opinion that since the aspect of citizenship is concerned, a fair opportunity may be granted to the petitioner to contest the proceeding. Full stop. We are also aware of the fact that in the meantime, according to the judgment of the Honorable Supreme Court in the case of Sarvananda Supra, all pending reference would stand transferred to the concerned foreigners tribunal, which in this case would be foreigners tribunal. Which place? Jorhat. Full stop.
There's only one FT in Jorhat, I think.
Of Jorhat. Full stop. The instated petition accordingly is disposed of by directing the petitioner to appear before the FT Jorhat on 11th on or before 11th of September 2026 with the written statement and the affidavit and the evidence on affidavit of all the witnesses, and if such and if the same is done, the learned tribunal would consider the case of the petitioner afresh and in accordance with law, and culminate the proceeding as per the prescription given in Order 3, Rule 14 of the so-and-so Orders 1964. Full stop. It is, however, made clear that if the petitioner fails to abide by the aforesaid condition, the impugned judgment dated 4/3/2005 would be held to be effective and action be taken according to the same. Yes. Yes, please. See, you are not in touch. We can grant some more time. Not before, not after puja. We'll. Okay. See, it's a court of equity. Only because he comes to a legal service, he's already got a benefit. Okay, now we cannot give more benefit. He should be treated at par. 11th, let it be there. And let a copy of this judgment be also served upon the State Legal Service Authority for onward communication to the petitioner in accordance with law. We can also give you a copy, okay? Let a copy of this judgment be served upon B. Nath, the Learned Legal Aid Council, as well as to the Assam State Legal Services Authority for communicating the same. In accordance with. Okay. So, we can- Before we want to do the 19 matter. What is your difficulty today? What is your difficulty today? Is it okay? Day after tomorrow. Okay. On the request of Sri H.A. Ahmed, Learned Counsel for the petitioner, matter is adjourned to be listed on Wednesday. Please give the date. ATM or idiot. Sorrow to Matidi.
I can serve.
Petty number
7.
sound, not hear to sound, record to sound. Mr. Sharma. By the way, is Asmita Chaliha related to you? Is Asmita Chaliha related to you? Okay. Congratulations. Proud moment for Assam and India. We thought probably badminton, and we all know with reverence Pradeep Chaliha. So, Goldies. Yes, which part? Yes. Yes.
Husband's name also. Yes. Elias is written afterwards. You know, let's say before the comes out.
Gulenara Begum, Muhammad Gulenara Begum, Sami Mita, Motiul Motiur Rahman. Now, what do you want to submit, Mr. Chali? Husband's name? Here, no, here is also Motiul, Urofe Motiur.
Okay, I think later. You're watching with me before from the server. Next side.
মহাশয় বিনীত নিবেদন এই যে নোটিছত উল্লেখ কৰা মতে গাঁৱত উপস্থিত হৈ গাঁৱৰ মানুহ সোধ-পোছ কৰি আৰু গাঁওবুঢ়া সুধি-পোছ কৰি জানিব পাৰিলো যে তেনেকুৱা নামৰ মহিলা উক্ত গাঁৱত বৰ্তমান নাই। উক্ত ক্ষেত্ৰত গাঁৱৰ দুজন ব্যক্তিৰ স্বাক্ষৰ চহী লোৱা হয় আৰু গাঁওবুঢ়াৰ পৰাও চহী লোৱা হয়। উক্ত আসামিক নটিছখন জাৰি কৰিব নোৱাৰি উক্ত গাঁৱৰ বিজুলী খুঁটা এটাৰ লটকাই জাৰি. Yes, sir, what is this? Para 2 of the চাবাচোন আকৌ এইখনত এনেকুৱা মানুহ নাই বুলি কোৱাত লটকাই জাৰি কৰিছে এইটো. Which page is the judgment? Page. 22, yes. Yes.
Eventually, seeing no other alternative predecessor, and the case and directed the testimonial to make judicial inquiry resolve the subsequently
Appeared.
then this notice was given to her, putting the alias
Hmm.
in other age.
Hmm.
That I have said it clearly, because I am not.
No, it was paragraph 2 very good. Paragraph 2 to put. It is not expert. It was
Solved. Then thereafter she came, she was given.
it was filed.
Ah.
Then with periodic inquiry, when it was found,
Then
they
it was read.
contacted.
It got me.
LCR, yes. Now we can contest it on merits, Mr. Thalia, or are you contending? Are you contending that the procedure was?
Another court of law has been declared as 6
Those will consider.
And after this judgment law, my counsel informed this matter to court, but court has ignored it. They refused to keep the matter and maintain the order. And for these matters, I refer to a recent judgment of the Supreme Court on this issue. Is dated 11/7/24.
That's Sabitri. Sabitri we have seen.
There many things have been said about the criminal function. And another judgment is of 24.
Now, Rohim Ali, we have discussed in a number of matters. Rohim Ali, unfortunately, has ignored a full bench judgment of Sarvananda with utmost of respect. Perhaps it was not brought to the notice. We have dealt Rohim Ali in a number of cases. Again, it goes back to IMDT. If you follow Rohim Ali, again it goes back to which has been declared ultra virus. That is exactly what is. The requirement of notice, everything, the burden, everything, section 9 will again go for a toss. After a constitution bench, full bench of the three judges bench. Yes, Sabitri, we can definitely will have to take into consideration. But Savitri is only on the purpose, on the aspect of ex parte. How do you revert? How do you? No, those we can take care of. But once you have appeared and contested, the aspect of notices not being served at the first instance, that will not have any, and that will not be relevant for consideration. Because it was not.
I have mentioned in my
Yes.
that your final page
Page?
9
9. And you had filed a petition to correct the name. Now you have to contest, you have to urge on merits. What is wrong with the tribunal's order? It's not an ex parte, it's a contested matter. Contested, you can. Okay, you. Okay, you please argue on merits, we'll decide. Yeah, we will take into consideration. Let us see the decision of the tribunal vis-a-vis your documents by which you try to criticize the judgment, opinion.
So it is, so now it is constitution bends. It prevails.
Judgment of plain. Plain. No police. Oh. Muhammad Gulenur. Opinion dated 4/1/19. Page 22. I think. 19. FT, which one?
Step.
Morigaon.
Stepler one.
Okay. What is your date of birth or year of birth? Date of birth 1/7/60. 1960. And you had adduced evidence. How many witnesses were there? Sole witness. Sole DW. What are the documents? Can we see? Written statement filed when? When did you file written statement? On 26 September 2016. Page 9. Daughter of Abdul Jalil, born in whatever. Accident, married to whatever, sincere. Husband house. Your name appeared in which year? Can we have a look at the documents? Yes. First is the 1965 of father. Abdul Jalil is your father. Page 13. You- Oh.
Nineteen 65.
Where is it? Your grandfather is Nazmuddin. Grandfather is Nazmuddin. 12, paragraph 13. Abdul Jalil. Then 15 is what? Page 15 is 1970. Who is that? Abdul Jalil? Golbahar, who is Golbahar? His mother. And Nur Jahan Bibi? Who is Nur Jahan Bibi? Stepmother. Then at page, what is page 70? 17? Certified? That I have checked this record in nursery record. Page 18. Headmaster. Exhibited. Mr. Sharma, please check this school certificate in the original records. And that was, this is not very legible. That is why I asked him to see the original.
Only one witness.
When was this certificate issued? 28. Student of class? Thereafter? This was not proved. 20 was not. Page 20 not proved. Not proved. Where is your voters list? There is no voters list. Then the only connection, you say you were born in 1960, prior to the cutoff date. So if you can prove your birth on the such date in India, your duty, you will be discharging your burden. Now, you say you were born in 1960, and to establish that, there is one school certificate which is at page 19, the original. Now that school certificate says that in 1979, you were aged about 10 years. That means your assertion that you were born in 1960 is not supported by this school certificate.
19 years.
But even if you want to get benefit of this, it may still be a case that it is prior to the cutoff date of 1971. Because 79, you are 10 years, that means you may be born in 1969 or 70 also, doesn't matter. But here in this certificate, who has proved this certificate? She has proved, not the issuing authority. Name of the huh? But original, but your name of the father is there. No, original certificate, but who has to prove? Isn't it required to be proved by the issuing authority or any authorized person from that school? Because except this certificate, other documents perhaps will not be relevant unless you can prove this certificate. This is the only document.
School certificate.
School certificate.
This one.
এখন না এখন না
The other one.
এখন তো জাজমেন্টের ভিতর রয়েছে
This one.
at page 19. 19 would like to have a look at the original also. 19 would like to pay original
copy of 19.
page that school certificate.
Headmaster. Yeah, these documents. In terms of our law. It doesn't.
Going to Savitri. Savitri the expert is.
I just.
Zone 31, 12, 16. 12. So 10 years, 120. এই চাবা নেকি এখন অলপমান? এইখনে আচল। বেয়াকে ল'ম।
Sixty-one. It is below 61. Exhibit A.
Yes, anything else? We have, this was not before the trial record. Difficult for us, but still then let us have a look. Mr. Sharma, have a look. Ek minute. What is Joe Mutir or wife of? Yes. Of the judgment. Yes. Afuza Begum.
In these two cases, just be in the interest of justice. Because question of citizenship is there. Articles 14 and 21 very clear law. So, and considering these cases,
Mister, have you looked at this Afuza's case? Afuza, the projected sister, she was facing a similar proceeding in the same tribunal in Morigao.
Name is not there. Name is not there.
Paragraph 18, subject to the paragraph 18. What is it? Can you please read?
Reference to Raymond.
the comments and analysis in this case, on this fingerprint. Then it's necessary. There are printing. We have designed exit, voltage access, voting, and proportional and any person. Providing 24 is this, the expression in no person. And therefore, we want to confirm that this clarity law to the protection of law, life and personal interest is thereby available to every person. In this in this. In person, again, they upload the statement and publish in their system, but also value. That these are areas of the must deal that fairness, distribution, and normal changes. This code has consistently provided in the trainer type only protections of life to large have extent. Legally, we even that is to help right and legally and right in like we said in India under 92. This distinction is important in the present case. The state must regulate and state and human awareness in accordance with the law. Person concerned with not protection. We are talking to the same principle. Act we know as clear is the illness illustration. Very good. It for protective person. That person is principle. It's right to keep it. What was that? Reason and finding to it based on that. The occurrence of active training was probably a train by distributing information to a system of functions that was entire principle where that and development and people restraint of trade. I think it's possible to the income of the year of you related and if they next from all here you go the already the things is big on. What things if results may also means the very explainer and something indeed is mechanical. Once direct and devoid of penetration of mind. Reflection of or extra that by email, ears, and the email. It's not get the notice, it's only time and then the order is only fast. It does not examine and there possibility where the name goes, where this goes, where the expense, where and where the applicant knows on the previous before. Exercise must be hard. Document the maximum that both person and from their our patient cannot speak in the person in line or the liking to the vector must coordinate the origin also needs to be hard. Basically, therefore, here you know separate connection. Very exceptional in this type of cases, quickly.
In paragraph 3, 16, the final order containing the opinion, will be the concise statement of facts and this conclusion. Thus, even where the opinion expressing them is being prepared and adjudicatory function, the non-appearance of the required in the court, another person immediately does not limit the of the obligation to examine where evidence is supported by material published by say under section 9. Say section 9 4S, this is the guardian on the property. But the guardian does not convert the absence of proceeding of the allegations. The tribunal must be applied its mind the main terms of the parties, the evidence best for it and equations department. And this on this.
Mr. Chalia, those observations are made in the facts and circumstances where ex parte decisions are rendered. Three types of ex parte. One is not getting notice, one is getting notice and not choosing not to contest, and the third is choosing to contest and contesting for one stage and thereafter abandoning. On all those stages, there were judgments. No, that is in those 27 cases, there was no discussion to the foundational facts, and only on the basis that no evidence could be adduced or no pleadings could be, those opinions were rendered. But here there are discussions. Now, whether these discussions will be relevant or not, that those we'll have to examine and answer.
Just and proper in this case because in the name of a different person, she stated that in her document also clearly that I am not Gulianara, quite of motiveful or something like that. And your Oscar in the notice also.
Yes.
Clearly states that there is no person of that name. That means Gulianara is not there. Then they again put Elias, they put her name and Cardinal Chapel. For that, where they found how they produced her on their side, regarding the allegations in the judgment will not be submitted. I refer to those paragraphs here. Because they have not produced any further evidence. How I have been moving.
The question of evidence, will it come initially? First, unless you discharge your burden under section 9, then only the question of rebuttal evidence will come. Yes. No, you have filed your written statement. You have contested the proceeding on merits in the written yes. Correct.
I cannot avoid that, I avoid that to create more trouble for her person.
So she appeared and claimed that she was not
She is not Gulen.
Gulenura.
Husband name is a different name in the original notice. So in this argument, there is about the notices and other things also.
Yes. Yes. Mr.
That name person is not there.
Proce-
There are some change the name and then started with
Now, where is the part in the record regarding her the furnishing of serving her the notice? There is one report of the process server that such person could not be found, but that we have seen. But how is there anything how she appeared?
I didn't know initially that there was no notice again.
Please look at the order sheet. It's not funny anybody. Please. That is the report of the Jari Karak that we have seen. File, correct.
But name has been written wrongly. Yeah.
Honorable Tribunal.
I've noticed this.
Yes, sir. And she never break of strike of the hard and complete stem case fraud. And Lordship, after that of the contested case and also on credit, Lana Tribunal has published that constantly in Northern Indian citizen is a illegal migrant of 2 7 months trained of it. And Lordship here in this case, proceeding has to tell is the daughter of the will, he can reflect the banking by contradiction. And Lordship, it is obvious Lordship here is no specific feeling in respect of our parents' stamp of family laws, about her family tree, about her brothers and sisters. Lordship, nothing has been mentioned in this WS Lordship. And in this repetition, Lordship, some new grounds has taken by the Proceeding Lordship and stated by sisters so has been declared as an Indian citizen. If Lordship, if we see repetition Lordship, paragraph 10 of the repetition, then my younger sister of the citizen, namely After Begum, wife of Akbar Sheikh, who was also marked as a key voter and her case was referred to the coroner's cell from Morigaon in 1044 of 2007 and upon production of the document relating to her mother, the learned tribunal by order of 21/10/2016 has removed the doubtful voter against the her holding that against that of service, he will be removed from her rally. The petitioner to Lordship, her order was passed in the year 21/10/2016 and she filed her doubtless in September 2016 Lordship. And where her projected sisters order was given in October 2016, but in WS Lordship, there is nothing mentioned about her sister. Apart from that, Lordship, her evidence was given in December 2016 Lordship, and evidence also that was not mentioned Lordship that our sister was projected sister was declared as Indian citizen or he was removed against her name Lordship. So that was not mentioned. So Lordship, now we cannot take this benefit Lordship at this moment Lordship. And Lordship, there are so many settlements for this Lordship regarding deletion to this not permitted, registration deletion not permitted Lordship. In this regard Lordship, 2017 to TLC 1076 Lordship.
2017 name, paragraph.
Yeah, that's great. Citation, can you repeat?
17 to GLT 1076.
Paragraph 10 Lordship, and relation statement of petitioner was only inadequate and did not disclose any material characters about because the allegation of the stated petitioner was a coroner, therefore as per mandate of section 9 of the Coroner's Act 1946, it was the founded duty of the petitioner to have disclosed all the material characteristics within his knowledge in the written statement, but he did not do so. Petitioner neither mentioned his date of birth nor his age. He was silent regarding the name of his mother and the identity of the and maternal. He did not mention anything about his brothers and sisters or about his marital status on the basis of the reason. And it cannot be said that the petitioner had stated anything substantial to that he was not a foreigner but a citizen of India. And paragraph 13, the second position of lawyer whether party gets set up a case in this area, he will be debarred from producing evidence in his support and the case of trial. As a matter of principle, variance in pleading and proof is not permissible. So, Lordship,
That is paragraph 12.
we have the starting. And so, after 1970, in our evidence profit, it is my father died year of 1986, but after 1970, there is nothing.
No list.
Our father totally visited it. Our mother's name also not appearing. And
ইয়াতেও দেখাইছে ইয়াতেতো একদম কৈ দিছে ইয়াতেও কৈ দিছে ইয়াতেতো বেছি লিড কৰিব লাগিব তুমি সৰ্বনাম 17 পেৰাগ্ৰাফটো কৰিছা at times grandfather কৰিব লাগিব grandfather father mother siblings ইয়াতেতো এইটো ৰিকুৱাৰমেণ্ট মোৰ হ'ব ইন ভিউ অফ সেকশ্যন 9 19
now, petitioner has stated that Gauhati is her mother, is Gauhati, but he the evidence of it here in the record.
page is it there of the or record
My biological mother is India Khatun.
of not Golbahar
Here is not a single document respect of India Khatun. Please, okay. Okay. Before we go. My humble is that we are under statutory jurisdiction of this we are only to see whether the opinion of the tribunal is good or bad also. So Lordship, I think Lordship, there is no information to opinion for the tribunal, so opinion may not be disturbed. There was not to account and here another certificate has been annexed, which is considered to them two certificate which is reported tribunal and date of birth is totally different option. And even before this court also if we present voter is 1993 voter is now petitioner has submitted before the court also. If we see this then our date of birth is 1959 also. So everywhere there is a discrepancy in respect of date of birth.
Okay. Anything, we'll consider to close this? Hard.
Minor discrepancies are quite different. I mean, it's not or a. Let me know whether it is 60 or 69. In days plus. It's very nice. And the original since the original is here and that was existed. I was that is two certificate. The original was a big super book and that was the register. So this is exhibited to us, contents, when it's book.
But what about the settled law? Mere exhibiting or mere marking of exhibit will not fulfill the requirement of proof of the document.
Yes, it's different. The original is published. So at least that is for work. That's going to certificate. Where the thing again. Regarding the first order.
Yes.
And say since it's the case where we left on our part, but it was not mentioned in the trial. Instead of the council change for the criminal type of argument as for his death and the party matter to go. That was what to get for those. So for fair trial, no, the case for the non-commission. I said that is notice, notice. There is no notice in her name.
Correct.
Say that there is a case previously, and that's why I see it here. So, without a notice. Suspect. Here in the state here.
But written statement, she has, as pointed out, right, she has not really said that I'm not this person at all. That my name has been wrong. I mean, that can be a mistake in interpretation on her part, but that I understand. But still, it reads like that.
Okay. Heard. Shri D.P. Chalial, the senior counsel assisted by Miss M. Roy, also heard so and so. Pura likhe diba, huh? Give the list who's appearing. Hearing is concluded, judgment is reserved. Can you must be look at very well. This you can take it back. We'll have a photocopy made. This 1993. Just Madam Roy. Yes, it is. Item number?
Item 5. Plan B. Yeah.
So Ahmed, how long will you take? We will go for disposal of this matter. No, we'll go for disposal.
Half an hour to like.
Half an hour.
This.
What is the case about? Contested. How many witnesses? 2 witnesses. Okay, we have, brother has single bench. This bench has a single bench. But we are not very sure whether will be, but brother has to sit. We'll have the, on some other dates, okay? No, not next week. These are all matters. We'll have it on Wednesday. Whatever is possible, we'll try to, chronology wise, we'll try to
19 matters.
address matters of 19, 18, whatever is there. Whatever is possible. Okay. Paucity of time may not permit the matter to be taken up today, list on Wednesday. Baki na lage. Baki, Purana matter didi hoy, it Thursday or Friday didi. Baki tar tatke nahi. Rest may not be possible today. Single bench or matter আছে নহয় মোৰ এটা কিবা পাৰ্টাৰ হৈ আছে নেকি আছে নেকি matter হেৰি হা ক'ত আজি নোৱাৰিম নেকি মোৰ matter আছে কিবা কিবি মিটিঙো আছে আহি উঠি যাম বেলেগ এটা ডেট দি দিম No, there's some disruption in the bench formation, so probably may not be possible or not. Mr. Nath is recovered. We can have it some other day whenever this bench should be available. This week it may not be possible. DB, after DB is... Yes, madam? Here for the petitioner. We'll have some other day then. Okay. Okay. None appears for the petitioner when the matter is called upon. Full stop. Further, this bench further, this is not a regular bench, as this court is in a division bench for this week. Full stop para. In view of the above, matter is adjourned to be listed as and when this bench would be available. Okay.